Good afternoon, Your Honor.
Good afternoon, ma'am. Who's up first?
Okay. Mr. Waldron.
Well,
Good afternoon, Judge.
Visit Mr. Greg Waldron all the way over here.
Made it over just in time for arraignments.
It's from the great county of Gregg.
That's right.
Is Judge Charles treating everybody fairly over there?
He is. He is. We can't complain about Gregg County.
I would expect
We skipped that one in the middle, though.
you skipped that one in the middle.
Yeah.
We better move on. We better move on. We are streaming. This is cause number CR 24-00039. Mr. Ronald Jack Edwards.
He's present.
Come on up, Mr. Edwards. All right, Mr. Edwards is set for arraignment. Have you had an opportunity to go over the indictment, Mr. Edwards?
Yes, sir.
Are you ready? Go ahead, Mr. Waldron.
Judge, we're ready to proceed with a plea of not guilty. I want to give the court a little bit of an update. He is currently in federal custody on a revocation of his supervised release. He's got about he's got about a year left. We're waiting for the marshals to pick him up just so the court will know as far as future settings. He was released on a PR bond on the state charge prior to indictment. He was taken into federal custody. For whatever reason, the Marshal Service in Tyler somehow sent him back to you guys. So I'm trying to get him in federal custody to finish that sentence. If not, I know how the Bureau of Prisons will do. They'll try to stack him after we get done here. So I just want to let the court know he may be moved back into federal custody. The other thing I want to let the court know, and Mr. Edwards doesn't know this, I haven't had a chance to tell him, but Smith County, the tag unit, has indicted him there on an engagement case surrounding these offenses and similar offenses. So right now, I'm not sure if this is going to stay in Van Zandt County or if ultimately it's going to be relinquished to Smith County. And I've not had an opportunity to talk with anyone regarding that. We're entering our plea of not guilty at this time, but I just want the court to know the issues that are involved around this.
Right. Is his name spelled in the indictment?
It is.
All right. He understands what he's charged with and the range of punishment.
He does, Judge.
All right. Court will find that Mr. Ronald Jack Edwards has waived the formal requirements of arraignment. His name is spelled correctly. Court enters his plea of not guilty into the record. We'll set this matter for pretrial. Is there any update from the state attorney on any of the issues raised by Mr. Waldron?
I'm sorry, Your Honor, I don't have an update. If the court would like, I can spend a few minutes and look into that.
No, that's okay. I just didn't know if you already knew. All right, court will set this matter for pretrial, understanding that Mr. Edwards may not be available if he's detained federally. So let's just best I can do, Mr. Waldron, is just treat it like I normally would. And we'll see whatever happens with you. Looking at my calendar, would you be available on either May 2nd or May 16th?
Neither one of those dates, Your Honor. I'm sorry. I'm out of town a lot in the month of May.
What about May 28th?
May 28th, I could do that.
All right, court sets Mr. Edwards in for pretrial hearing May 28th at 1:30.
And if anything changes on the status, state and I'll work, let the court know.
Thank you, Mr. Waldron.
All right.
All right, Carrie Lynn Sanders, CR 22392 for arraignment. All right, go ahead, Mr. Waldron.
Judge, we have received a copy of the indictment. We understand the charges. His name is set forth and spelled correctly. Enter our plea of not guilty to the charge here at this time.
All right, court will find that Mr. Sanders has waived the formal requirements of arraignment. Court enters his plea of not guilty into the record and sets this matter for pretrial on May 28th at 1:30. Should Mr. Sanders make bail, then this hearing will be at 9 p.m. that same day.
Thank you. And Judge, I'll get with the court. I need to check the bond status. I know he was on a PR bond pre-indictment. I'm not sure what the bond is currently set at, but it may be a situation where he is able to bond out here in the near future. And it maybe we just need to get a motion in front of the court. But I'll let you know.
I'm not aware of what it is either without looking it up.
Okay.
I'm sure the jail can tell you anyway.
This is another one where he went on a revocation of supervised release, and that's where he was for about 15 months. Somewhere around there, and then they brought him back here to county once he was done with that sentence.
Very well. All right,
Thank you, Judge.
You're welcome. Good to see you. We'll see y'all on May 20th.
Okay, thank you.
Anyone else ready?
Let me check. No, Your Honor, it's gonna be just a few minutes.
What about some of these individuals who don't have lawyers?
I need to get, okay, now remember Mr. Mills is the one that you and I looked at yesterday?
Well, I was thinking more like Donica, Goss, Mills.
Well, I showed that Donica had no financial need recently. I'll get him to bring those three up.
Okay.
Your Honor.
Yes, ma'am.
Right, Mr. White is ready, and then I have the two gentlemen, with the court-appointed attorneys questions.
All right, Mr. Melvin, if you'll come forward, this is call number CR 1763, CR 17466, CR 258. So that here. Before we get started, it looks like Mr. Melvin, having been charged with a third-degree felony, possession of controlled substance, would be pleading guilty today on the state's recommendation of 5 years in confinement, prison suspended for 5 years, community supervision, $180 restitution, $290 in court costs, $85 in reimbursement fees. The state would be dismissing under section 1245. Another third degree possession of controlled substance, also a third degree hindering apprehension or prosecution. Does that sound right, Mr. White?
That's correct, Your Honor.
Okay. All right, Mr. Melvin, sir, if you'll raise your right hand, I'll place you under oath. You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Glory. Your name is Joseph Edward Melvin, is that correct?
Yes, sir.
And Mr. Melvin, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition? I'm sorry, I couldn't hear you. Have you ever bipolar, schizophrenia, multiple personalities, schizoaffective disorder, PTSD, depression, anything of that nature?
No, sir.
All right. In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with Mr. White and work he's done for you as your lawyer?
Absolutely, yes, sir.
And do you feel like you've had enough time to talk with him about your case and that you've had all of your legal questions answered?
Yes, sir.
You've signed some paperwork here today, Mr. Melvin. Do you understand everything that you've read through and signed?
Yes, sir.
All right, Mr. White, do you believe Mr. Melvin to be competent?
Yes, Your Honor. I believe he's aware of all the decisions that he's made today.
And do you believe that he's entering into this plea intentionally, knowingly, and voluntarily after you've explained to him his legal rights?
I do, Your Honor.
All right, Mr. Melvin, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1 between 1 grams and 4 grams. A third-degree felony does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison and a fine of not more than $10,000. Understanding the range of punishment in the plea agreement, Mr. Melvin, how do you plead to that offense?
I'm guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
The court will accept the defendant's plea of guilt. Mr. White, any objections to the stipulation of evidence?
No objection.
Stipulation is admitted and the court takes judicial notice of Mr. Melvin's judicial confession. Is there anything from the state?
Nothing from the state, Your Honor.
Anything from the defense?
Your Honor, I would like to address one issue on his terms and conditions of probation. We have 360 hours of community service. In his condition, I don't believe he'll be able to do anything at all physical.
I was going to ask.
I guess officially we'd be asking for the court to waive.
I was going to ask whether or not he was going to be able to comply with all of the terms and conditions, including payment of fines, fees, probation fees, restitution, court costs. Is he going to have the financial ability to pay those things?
I believe so, Your Honor. I believe he's going to be on Social Security pretty soon.
What's pretty soon though, because he's gonna be,
Next month, I believe he turns 65.
let me review the evidence before I make a decision on the community service. All right, before we go any further with the plea, have y'all Mr. White, have you discussed Mr. Melvin's incapacities with the probation department to see if they are in agreement with waiving the community service and or if they have other alternatives for Mr. Melvin to comply? I know we have other individuals who are, writing, reading and writing book reports and doing other alternative things to physical service.
Ms. Burns is right here. I guess I could ask her right now.
Yeah, let's just go there and step over off the camera and talk to her for just a moment. Let's get her opinion.
Your Honor, Ms. Burns winds up saying that she would be willing to waive his community service.
All right, court has reviewed the evidence in this matter. The court finds that there is sufficient evidence to convict Joseph Edward Melvin. Court does follow the plea agreement today, hereby convicts him of possession of a controlled substance of penalty group 1 between 1 grams and 4 grams, a third-degree felony. Court assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice. Based on the state's recommendation, the court will suspend that sentence and place Mr. Melvin on 5 years community supervision, ordering him to pay $180 in restitution, $290 in court costs, and $85 in reimbursement fees. Court dismisses under section 1245, clause numbers CR 25-8 and CR 17-466. Court will waive the community service restitution as a term and condition of the community supervision. Mr. Melvin, you hereby remanded to the custody of the Van Zandt County Probation Department so they carry out the terms and conditions of the sentence. I'm going to have you go over with the deputy to be fingerprinted, then the probation officer will tell you about what's next.
Your Honor, I believe that's all I have today.
Thank you, Mr. White.
So your fingerprint right there at the table. Okay. Your Honor, on Stephanie Goss, I was not aware, but she's been housed over in Hopkins County, so she's not received the 2 affidavits that I have sent out here.
Okay.
So she has completed one. She's been unemployed for 2 to 3 months and she has no assets. So I will appoint Mr. Schmidt.
All right, then the court will enter Mr. Schmidt's appearance for the record based on the appointment. Court will reset Ms. Goss for the next contested evidentiary docket, which will be April 30th at 1:30. And Ms. Goss, if Mr. Schmidt works on your case and reaches some kind of agreement before then, and he'll notify the court and we'll get you in for.
Okay. Thank you. Am I being kept here or?
I don't know. I just noticed they have. We don't have to take over that. All right. All right, Your Honor. Tyler Donica. You'll come up here.
For the record,
He had no financial,
you know, just for the record, this is cause number CR 21-285, State versus Tyler Scott. Don, go ahead, Mr. Graham.
he had no financial need. I believe he owns a vehicle that was paid for and he resides with his family. And he's telling me that he can no longer, that he cannot retain an attorney. Is that correct?
Yes.
Why is that, Mr. Donica? If you have assets, don't have any debt and bills, then you
I
have.
haven't had a job for over a year and I just had a baby, so. I
Do you
live
have-
with my
do you-
family, so they help me.
Do you have a car that you can sell?
If they'll let me sell it,
Who is they?
my mom,
Does your mom have a car or do you have a car?
me,
Okay, is it in your name?
I believe my grandma's.
So you don't have a car?
I guess like that, sure,
Well, I need to know, how old are you, Mr. Donica?
24.
24? Is that right? All right. Your mama's not here, your grandmama's not here, I need you to pay attention, you're a grown man, you're in jail, so I need you to listen, pay attention. Do you own a car? Do you have a car that is, listen, you're not listening, you're already not listening, I'm trying to explain something to you. Do you own a car that is in your name, you have the title, that you can sell, that is an asset, that you could use money from to hire an attorney, yes or no?
No.
Okay, so on your affidavit, it says, list all the things that you own. You fill that out incorrectly. You don't own a car. Your mom owns a car or your grandma owns a car. Is that right?
Yeah.
All right, then fill out the paperwork and get it right this time because all we can go on is what you tell us. So she's gonna give you more paperwork, you fill that out. If you fill out paperwork and you tell me you own cars and boats and guns, then I'm gonna expect you to sell cars, boats and guns. Because the taxpayers of Van Zandt County is not gonna pay for somebody to have a lawyer who has the ability to pay for themselves. But the only way that we know that is based on what you tell us. So it's time to grow up and figure out what you own, what you don't own, and put all that on a piece of paper that you swear to, and it becomes a governmental record, and we can rely on it. And if you don't have any of those things, then put that you don't have any of those things, and we can go to the next phase and perhaps get you an attorney. Does that make sense? All right, no one's gonna listen, Mr. Donovan. No one's gonna help you here except yourself. So it's time to help yourself, okay? So, Mrs. Abraham, if you can give him some new paperwork.
Yes, sir. Okay, Your Honor. This is Mr. Mills.
All right, for the record, cause number CR 21-229, State versus Jeffrey Alden Mills. Go ahead, Mr.
Okay, he had no financial need also. He's the one that we were looking at his paperwork where he filled it out the second time. And I believe you had a vehicle.
My wife went and purchased, she took a loan out for a car, because she didn't want to get back and forth to work. She didn't buy the vehicle, she's just making payments on it.
She's purchasing a vehicle. And it seemed like you had something else. I didn't bring paperwork.
No.
Do y'all rent?
She lives with her parents.
Guess I'm confused. What? He was.
I believe he had $1,075 or something in transportation cost.
For a car, the car payment, car insurance, and the gas,
Okay, but then on the income, what was your wife's income?
2,600.
And then,
She pays the utilities at the house, her cell phone bill, groceries and everything like that.
So what he's saying now is he doesn't, are we saying he doesn't meet financial needs or he does meet financial, I guess. I'm confused. That's-
well, I mean, they're purchasing a vehicle. Do you know what she owes versus what it's valued at?
I do not have. I know she just got it. I think she said it cost 14,000.
So are you telling me that she's not gonna be financially able or willing to
No, sir.
hire an attorney for you?
I'm sorry.
She's just gonna leave you in jail?
She can't afford to pay for one, sir.
All right, Mr. Abraham, I'll send you a message.
Okay.
You can have.
That's it. Okay, I believe we're gonna need a few minutes. Mr. Manning is going over plea papers.
Okay, over.
And I have not seen, Mr. Story. Attorney Sean Story. And then Mr. Smith is on vacation and he was just appointed on these two motions to revoke. So do you want me to reset those or bring them up?
Go ahead and reset the ones for Mr. Schmidt and just make sure that they know.
So April the 30th,
Are they MTAs, MTRs?
I believe so.
No, I don't think so. Yeah, one is MTR. Yeah, they're both MTAs.
Uh-huh.
So just set them on the next contested docket and let them know.
Because Mr. Richards was set for sanctions court this morning, but he had been arrested. So he has a motion to revoke.
I'll go double check the file to make sure that the story did file a waiver. And then, what about? And then Mr. Lowe, on Mr. Gerard, we reset that to May 16th based on his
Yes.
motion. So I'm not sure the state was aware, but state, we've granted the defense motion for competency. I believe he's still waiting on an expert report. So that's reset to May 16th. And then also on CR 22-357, State versus Jodine Walters Lewis. Ms. Lewis hired Mr. Ron Harden. He filed a motion for continuance, and the court has set that to the next contested docket on April 30th. Okay, so we'll give Mr. Manning some time, and then I'll send you a message on those other ones.
Yes, sir. Your Honor.
Yes, ma'am.
Mr. Story is ready.
All right, let me get a court order.
Okay.
All right, court calls cause number CR 23-94, State versus Kiera Lachey. Is it counts?
Yes, sir.
All right, Ms. Counts, set for arraignment. Mr. Story, have you had an opportunity to go over the indictment with Ms. Counts?
No, Your Honor, I haven't had access to an indictment.
Stand by.
If you're doing, all I have to
Yes, sir. She says that her name is spelled correctly. And she's aware of the charge.
All right, court will enter Ms. Counts' plea of not guilty into the record, find that she's waived the formal requirements of arraignment. Court will set this matter for pretrial hearing. Mr. Story, are you available on May 2nd?
Yes, I've made arrangements with the coordinator and we've signed a pass slip with that date.
Okay, well, it's not gonna be a pass slip, this will be a notice of appearance. So
I'm sorry. Yes, sir.
we're setting this council for May 2nd. And you'll need to have any pretrial motions filed 7 days prior to that date.
Yes, Your Honor.
All right, Ms. Counts, if you make bail in this case, the hearing will actually be at 9 o'clock on that day. If you don't make bail, then it'll be at 1:30. Okay, we do jail in the afternoon and bail.
Yes, sir.
And Your Honor, just for record purposes, we had Mr. Schmidt in as the appointed attorney, so Mr. Story hasn't gotten any discovery yet. We'll work on getting that fixed as soon as we can. We'll get with Mr. Story, make sure he has portal access.
I appreciate that, Judge.
Okay, all right. You'll get access to Mr. Story so he can go ahead and review the discovery. We'll appreciate that. I'll see you back on May 2nd.
Yes, Your Honor. Thank you, sir.
Thank you. This one.
Okay, Your Honor, well, Mr. Manning's over here discussing something, okay, on Tyler Donica, we're going to appoint Mr. Manning and reset for April 30th. Stephanie Goss is Mr. Schmidt, and April 30th. And then
Okay.
Jeffrey Mills will be Richard, and I also set that one for April 30th. Even though it's not an MTR.
Does he have any settings, in April, April
I
16th?
believe April 18th, 16th and 18th are getting full, if I remember correctly.
Let's see, April 16th has 53 and April 18th has 30.
Okay, April 18th is
But
his
he's,
day, right? No, he'd be the 16th, right?
he's the two, yeah, let's set it for April 16th.
Okay, 16th, okay.
Set that for a rate. And I'm sure he'll probably wait, but that way it's sooner rather than later. Mr. Jones.
Okay, so 16. Okay, and I think that was all of that. Okay, because Mr. Tadlock, we're resetting for Thursday.
All right, let's put that on the record. This is cause number CR 2376, CR 23190, CR 23191. Mr. Tallock in there. CR 23192, CR 23193. Is Mr. Tallock in the courtroom? Joe?
Judge, no, the jail asked that since he was not being taken to custody, instead of having him searched and all that stuff to have him come and go, they asked if he would just reset. I have to explain to Mr. Tallock that the deal is still, as we previously agreed, we were just wanting the paperwork to more closely reflect that. He is gonna come on Thursday at 1 p.m. And then he's also coming to my office tomorrow at 9 a.m. to go over the paperwork, get everything signed up so that we won't have to wait around on Thursday.
Okay, good. All right. Court will set Mr. Tallock and all of his cases on Thursday, March 28th at 1.
And on Richards, to Wendy Paul and Mr. Richards, I had them sign resets for April 30th.
Excellent. That'll work.
And then next judge, I'm ready on Mr. Michael Davis.
Michael Edward Davis, if you'll come forward, please. This is cause numbers CR 22-176, CR 23-124, CR 23-125, CR 23-149, CR 20. I'm sorry. Yeah, that was the last one. CR 23-149. State versus Michael Edward Davis, set for docket call in each case. Go ahead, Mr. Manning.
Judge, as you can tell on the newer cases, we're still pretty early on. We're requesting additional docket call. I spoke to a witness or an individual who will be providing mitigating evidence to the state. And I've spoken to the state about that. We're going to get in touch with that individual. And we request an additional docket call for them to weigh the mitigation and make a determination on offer.
Hey, do you think 30 days would be sufficient?
Yes, Judge.
And yes, Your Honor, I think 30 days should give us enough time to both talk with the witness and then renegotiate the case with Mr. Manning. I think 30 days should do it. And I certainly don't want to drag the case on unnecessarily.
All right, we'll set Mr. Davis then for final docket call on May 2nd. Do you have any scheduling conflicts for that day, Mr. Manning?
Judge, let me check one moment. No, Judge, I'll be here all day.
All right, court sets Mr. Davis for May 2nd at 1:30.
Thank you, Judge.
You're welcome.
And Judge, finally, ready on Mrs. Fields, Rebecca Fields.
Stills, if you'll come forward. This is cause number CR 21-18, State versus Rebecca Fields. Motion to adjudicate, motion to revoke. Go ahead, Mr.
Yes, Judge. I was just appointed on Miss Fields' case approximately a week ago. I had opportunity to discuss that case with her as well as the state and probation department. And we've reached an agreement to withdraw the motion to revoke. or adjudicate at this point in time to reinstate her on probation with ISP as a condition of probation and extend her for a period of 6 months. Additionally, they're going to update the financials. We were able to confirm that she just has 34 hours of community service left. She had a balance of approximately $780 prior to the addition of the new stuff. And she understands that ISP is an additional burden, both financial and time-wise, but she's willing to take that burden on. There were some transportation issues that we discussed, but after looking at the situation realistically, I believe it's her admission to the court that she is going to be able to do what is ordered of her in this time period over the next 6 months.
Said probation is recommending this to the court.
Yes, Judge, I spoke to Ms. Burns about that. I'll let her address it more specifically if she wants.
Yes, Your Honor.
Okay, and do you have the paperwork there with you today, Mr. Payne?
She is finalizing it as we speak.
All right, Ms. Fields, if you'll raise your right hand on the completion of your oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. I swear.
You can lower your hand. All right, Ms. Fields, you understand that if the state withdraws their motion to adjudicate and I reinstate you on community supervision, that your conditions are going to be changed to include what's known as intensive supervision, where you're going to be reporting much more frequently, and your probation is going to be extended for a period of 6 months. That may result in additional costs, as Mr. Manning said, both time and financial in doing so. Is that what you're asking the court to approve today?
Yes, yes, I told him I was already in search for a job too, so I'm hoping that that's still available to me when I get out, because I haven't been in here that long. But yes, I do think once I get out to work, I can start on that, and I do have a lot of assistants that I gathered up in here to help me financially as I step out of here to get me started until I get a job and get my first paycheck.
And Judge, I would like to know for the record too, that she was placed on sanctions court previously, and she was able to successfully complete the sanctions court program prior to this revocation being filed. So I think given her commitment and given what she said, she should be able to continue on and do what she's supposed to.
Remind me, what was the revocation based on? Was it on a UA?
Yes, Judge, there was UA admission for alcohol, and there were she was short some community service as well as some monies as well.
Okay. All right, Ms. Fields, has anybody threatened, forced, or pressured you to enter into this agreement with the state?
No, sir.
All right, court will approve the state's motion to withdraw. I'll grant the order withdrawing the motion to adjudicate. Court will reinstate Ms. Fields on community supervision, amend her conditions of community supervision to include placement on the ISP program, and the court will extend her probationary period for an additional 6 months, as well as any of the other terms and conditions that are embodied in the agreement between Ms. Fields and the state of Texas.
Thank you, Judge.
You're welcome. And so on that reinstatement, there's also going to be, I didn't talk to her about this, but she understands that there's also going to be financial attorney fees. She understands.
Yes,
that?
Judge, I've already explained that to her. And we have a copy of the court cost sheet that's been updated by the clerk's office.
Excellent, thank you.
Judge, I believe that concludes my business. May I be excused?
Yes, thank you, Mr. Manning.
Thank you, Judge.
Okay, Your Honor, I believe that concludes our business.
Yep, I'll see you when you get back over here.
All right, thanks, sir.